as we do that today, we are your two lecturers for the day. My name is Dr. Shahid Hamouri, and I am accompanied with Dr. Tom Frost.
Hello. Good afternoon, everyone. Thank you for joining us on election day, no less. For those of you who are probably going to be voting for the first time, welcome to the democratic process.
So I'm going to start first with a presentation. Just gonna again wait 1 more minute before I share my screen with you.
Thank you very much. So the title of today is looking at the legal legacies of slavery and empire. So we're going to have two complementary presentations for you, but we're going to look at kind of the importance of empire, not just for the UK in the 21st century, but also around the world, and the way empire or colonialism has gone kind of hand in hand with corporations and businesses.
And so I'll start with sharing my screen. Tom, can you confirm?
I can see that. Yep.
Perfect. Okay, so I'm going to be covering the corporation bit in relation to colonization. And why is that? So to start with, as I said, my name is Dr. Shahid Hamouri, and I'm a lecturer in law here at the law school. I am currently authoring a book called Corporate War, Profiteering, and International Law. This has been my topic of focus for the past 10 years. I'm also sometimes a practitioner in international law. I consult and research and look generally at corporate accountability, but also issues of public international law. So what I will be explaining to you today actually touches on multiple of the modules that I teach. You would see me in critical introduction to law. This module might be changing when you come in. I will be also convening critical legal theories, which would be one of the primary topics you take in the first year. So you'll see as I discuss somewhat of a focus on kind of what are the presumptions behind the law and the ideas and the theories behind our thinking about the law. And I'll talk about this a bit later on. I also teach public law too, which is a module that will follow up on what Tom will explain to you, which asks the question of what happens after we think just about the state. So public law 1 is focused about the state and its structures, as Tom will tell us. Public law 2 is talking about, well, the world is changing. We live in an interconnected world with globalization, with privatization. How is it that we understand the role of the law with that in mind? I also teach and I focus on international law specifically, and that's where my practice lies. I teach public international law, principles and sources, and I teach international economic law as well. And I will be, while you are at Kent, hopefully, I will also be leading a module on corporate accountability, where I kind of also base some of my practice into my teaching and kind of tracing and mapping out all the different ways with which we could hold multinational corporations accountable for any harm that they would cause to communities around the world. So now you kind of have a background on who I am and what I do. And with this presentation also, what we're hoping to give you is a taster of how the ethos at Kent works. And aside from being a very engaged law school, we are very focused on critical approaches to the law. As me and Tom hopefully will show you, that means that we don't only talk about law as doctrine and law as a separate discipline. We do what is usually called interdisciplinarity, which is to think about all the different things that surround the law. So law does not only exist by itself, but there is political, sociological, and even psychological factors that play into the making of the law. And we're always asking ourselves questions about how is it that law is understood among these larger disciplines. And we believe that this is very vital. And we believe that sometimes if we only just think about the law, then we have a very narrow perception of the bigger picture. And it's harder to understand how things are happening. Further, we are also very proudly critical in the sense that we do not take things for granted and we don't take things as they stand. We always ask ourselves if there is a legal framework, not only how did it come to be, what are its inherent biases, what does it serve, or how could it be shaped in a different way? What is the background around it, and how does it engage with people? We will always seek to invoke your curiosity about things and engage with you. So the key here is creativity, but also we focus a lot on your agency, on developing your own forms and ways of thinking. A lot of students have told me that studying at Kent in comparison to other law schools is like going to the IGCSE system in other schools and going to the International Baccalaureate, if any of you are familiar with it, the IB system with us. Because what we're always trying to do is to invoke engagement, creativity of thought, and also allowing you to use that information not just to become a worker or a lawyer, but also to engage with you to develop your own thinking as a person and as a human being. And that's what we hope to see further. After my very long introduction, so as I said, I have a little bit of a taste for theory. And it's important when you go to law school to understand that what we're teaching you is what you can call a language of law, a bunch of legal concepts that we're helping you, that we're giving to you to navigate the world with and to navigate your own practice with. But so humans create legal concepts to understand the world around them and to govern it. Govern is a key word here. But different cultures had different approach to governing the world and different concepts. Not everyone around the world understood complex human relations the same way. So, as Tom noted, what we'll be discussing with you today revolves around a big keywords of colonization and imperialism. And indeed, this theme does feature a lot in the work of both me and Tom. And as you can see, a lot of the time, what we're trying to do is to engage students with our own research and how we engage with with practice and with other academics. So colonization is when one group of people goes and dominates another group of people and then exploits them for their own benefit. So from an international legal perspective, it is called alien domination, subjugation, and exploitation. Herein, under the Declaration on the Granting of Independence to Colonial Countries and Peoples, the subjugation of people to alien domination, to alien subjugation, domination, and exploitation constitutes a denial of fundamental human rights and is contrary to the Charter of the UN and is an impediment to the promotion of world peace and cooperation. Another important keyword here is self-determination. It clearly says that all people have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Here, what we're saying is at the heart of the international legal system is that each people get the right to determine their own future. As Tom had noted today, for example, in the UK, people are going to vote. They're going to decide what is the political system that they believe represents them, what is the economic system that they think is best for them, to decide how is it that we would like to run our community. So that is the basic principle of the people's right of self-determination. Colonization is depriving people of the capacity to decide for their own selves, and not only that, to be able to pursue their own development as a community. So from the 16th century up until modern times, we've seen a rise of colonization that is centered and led by European states. And of course, there's a lot of discussion in relation to capitalism, that capitalism and colonization go hand in hand, because one of the main ideas in capitalism is that you want to accumulate more and more and more money. And one of the best ways to do it is to go and force other people to do cheap labor, extract their resources, and then come back and use that in the manufacturing internally and develop even more money. And sadly, that is the reality of the world into which we were born into. A good part of human history has been shaped by the domination of other peoples. And now we call them states of the global south, others call them third world states, but these people were systematically deprived of their right of self-determination for hundreds of years. We usually talk about how physical force was used in colonization. If you've watched Pocahontas, for example, you would have seen how the soldiers who are here, supposed to be Dutch, I believe, went into, or was it British ones who opened Virginia, who discovered Virginia? I'm not 100% sure. At this idea, they entered Virginia, and holding their own weapons, they scared off the indigenous people. And then, if you remember, they were singing about the gold that they wanted to exploit. The indigenous people did not have the same relationship with that land, did not look at the mountain and said, oh, private property, I want to exploit it, but rather looked at a mountain in a very different understanding of give and take. But then the other element there is not just the use of weapons against these people, but through economic force. And how is it that we mean economic force? So exploitation, and this word, is to take advantage of and another person for one's own end, to pursue one's own gain at another's unfair expense. And this reference comes from Susan Marx's work, Exploitation as an International Legal Concept. Susan Marx is a very well-known Marxist theoretician in international law. So here, what she's trying to say is that we need to have a better understanding of the notion of exploitation. And exploitation played a very big role. And by here, what I mean is, there's a mountain that was there in Virginia. The indigenous population had a relationship with that mountain that wasn't based on private property. Then comes the settlers, and they say that no, there's this concept of private property. And based on that private property now, because we put a flag on this mountain, it is ours and we get to exploit it. And because you didn't put a flag before us, or you didn't sign a paper that says that this mountain is yours, you will now work as cheap labor for us. So the law was somewhat used and configured in a way to allow a legal framework for exploitation and to facilitate economic coercion. Because then law established another premises here, and that is debt. I will make you work in the land that I declared myself to own. And then I will put you into debt for asking for some money to make ends meet. And of course, there's a lot of discussion about this. So it's very much like when you were kids and you were playing a game, and some kid comes in and says that these are the rules of the game that I would like to create, and everyone else has to follow the rules of the game. And if you don't follow my rules of the game, you will be losers. Exactly the same type of attitude. So meanwhile, what is a corporation? So in all of these different parts, there was no concept of a corporation. A corporation was a concept that came about in Europe and then was transplanted abroad. So the corporation is a fictional legal person that is separate from the people who create it. What do I mean? I mean that, for example, if me and Tom go tomorrow and we say that we want to start a business together, we create a corporation, and that corporation under the law becomes a separate person. So corporation A becomes a separate legal person that has a separate legal identity to both Shahid and Tom. And again, this is a legal concept, an idea that humans made, and it's very important to remember that. But the thing is that then that corporation becomes separate from us. So even if we get the profit out of that corporation, there is still like a legal veil that is then established between me and Tom and the corporation. So at a lot of points, the corporation could be doing a lot of things, and we would be like, well, it's not us, it is the corporation. So it creates a veil between us and the acts of the corporation. Furthermore, the purpose of the corporation under this idea is understood as maximizing profit. Of course, this wasn't always the case. When corporations were first established, there were ideas that, well, maybe when me and Tom create a corporation, maybe that corporation should first and foremost serve the community and then help us accumulate wealth. For example, that was a discussion in the Burley Dodd debate. And there were other ideas. But the idea that became most popular is that no, me and Tom can create this body and it can do whatever it wants. A very interesting documentary in this relation is based on a book by Joël Bacan called The Corporation, A Pathological Pursuit of Profit. And there's a new documentary called The New Corporation. I highly advise watching them, and they're quite entertaining if you're interested in the topic of understanding the corporate form and how it allows the accumulation of wealth. So now we've looked so far at the concept of colonization, and we said that colonization is built on and facilitated through domination and exploitation. And a lot of colonization came through economic exploitation, and economic exploitation was somewhat facilitated through legal concepts like private property and the corporation. So with the corporation, we have this very separated two realms of the existence of the world. There is the state that cares for the people, and there's the corporation that only cares for itself, which creates a very weird legal space because the corporation can also affect people's lives. Colonial corporations then came to rise, such as the Dutch East India Company and the Levant Company that I'll be speaking of very shortly. And these corporations had the capacity to shape the indigenous people's lives, but then these people were not able to hold these corporations accountable or discuss with these corporations their power, because these corporations were saying it is private business, and has nothing to do with the public. Again, these are legal concepts that were somewhat created to shield these corporations from scrutiny and to allow them to extrapolate as much resources from the colonies as possible. If you watch, for example, Pirates of the Caribbean, you would see the Dutch East India Company as the main company that is fighting the privateers, the pirates. And sadly, you don't see a lot of movies about the Dutch East India Company, even though it is historically the biggest company that existed. And it's one of the main premises of British Empire all across the world. And up until today, you can still go to the Albert and Victoria Museum and see a lot of the wealth that was accumulated by the Dutch East India Company. At some point, it was even a sovereign entity in some parts of India. That meant that they could practice governmental capacities without any foresight, without anyone controlling it. At that time, we didn't have labor laws, we didn't have human rights law, we didn't have any mechanisms to oversee that, and that had meant that they were able to run free and to claim the corporate form to allow them to escape scrutiny. So this is reiterating what I just said, in the sense that the corporation is a private person that was used to bar any contestation of the exploitation of nature, of the relationship with the colonies. So here again is a reiteration of a theme that I already brought forth, which is the idea of private property. It's important also to note that the idea that a different group of people had an understanding of private property or not was used to say these guys don't understand private property, hence they are savages. There is wonderful work by an author called Dina Tazovala, who looks at how Europeans on and on again used these legal concept, the lack of knowledge of these legal concepts in other civilizations was used as a way to say, oh, these are barbarians, these are savages, and hence we can and should exploit them because they don't know better. And here is the idea that the European legal framework is universal. It's the ultimate truth, and everyone else has to know it. If they don't know it, they're savages. Again, the same concept as the kid who made up his own game. And if you don't know the rules of his game, you're not cool, and maybe yes, you are a loser. Almost the same way of, and the same logic. So these are thoughts that were already covered, and here is another very important keyword, and that is the concepts of private property, corporation, and other concepts in private law were transplanted into the colonies. And what I mean by legal transplant is when I put one legal system, immigrate one legal system from one place to the other. So here what Britain did is that this concept of absolute private property was transplanted into the colonies and then was used to allow the corporations to claim their own rights on the lands as well as on the people, and to facilitate the exploitation of the people. And here I come to the example of the Levant, where there was the Levant here is modern day Syria, Lebanon, Palestine, Israel, and Jordan. This whole area was one unity, and it was called the Levant area. So, and in the Levant area, there were actually multiple normative systems to control the relationship with land. There wasn't just private property, absolute private property in the Western understanding of it. For example, there was the idea of mashar, which is collective ownership of land by the farmers. There was also local elites had used very different frameworks in order to get taxes out of the peasants, but not claim complete private property over the land. But then with the rise of the Levant Company in the region of the Levant, there was the transplant of these laws from Europe into that area. And this is especially after the fall of the Ottoman Empire and the introduction of these new laws, which are foreign to the indigenous population, who have a very different set of laws, but because of economic coercion and power, now they have this very different legal system that was then used to exploit them and to allow the use of labor at the lowest cost possible to the investors. And in this case, it's the Levant Company. So British charter colonial corporations had an important role to play. To introduce to you the concept of a royal charter company, a royal charter is given, it's an instrument of incorporation that is given by the king at the time. So, for example, in case of the Levant Company, it was the Queen, and a number of investors would then apply to the Queen and tell her, we're the best people to exploit this area. And then she would give them the rights to exploit that area, and based on that, allow them to establish a corporation. So even though the profit was feeding back into Britain, it was all done under the veneer of a neutral, apolitical corporation that is just here to do business. But that corporation is building on economic and political and physical coercion and force that was then used to normalize their power. This is the Levant area that I described. And the Levant Company was established in 1592 through developing good relationships with the local elite. And here we find another dynamic, which is in colonization, which is where the colonizing powers establish very good relationships with the elite of the country that they are colonizing. And here I would reference the word of Frantz Fanon, who has spoken a lot about this relationship. So it means that the people in colonized areas would have a double exploitation by their own elite and by the colonizing entity. And later in its life, the Levant Company is the one that facilitated the transplant of European-styled private property and corporate laws into the area, establishing the premises of further exploitation in the area up until our current day. So they allowed for capital accumulation, and I mean by that, like putting more money on top of each other, labor exploitation, and threatening the economic development of the local communities. Later, of course, and the Levant Company is actually quite interesting because it started with economic kind of change and coercion, building the laws, and then came actual colonization. This is almost the opposite of a lot of other colonies, for example, like India. So later came physical coercion with the Sykes-Picot Agreement, which split up the borders of the Levant, and that's how we have modern day Syria, like this modern day Syrian borders, Palestinian borders, Jordanian borders drawn. They were drawn by two guys, one French guy, Sykes, and one British guy, Sykes, and one French guy, Picot, and they established the borders. So here we see how with the economic influence and with the relationships with the elite facilitated later splitting this land up, of course, and we see the ramifications of that up in until today. And then there was in the League of Nations, which is the mother of the United Nations as we know it today, something called the mandate system. And it's a very colonial system that says that some people are not civilized enough, so they need the help of bigger states to help them get more civilized. This is very much rejected logic nowadays in international law, but back in the days, this was the norm. So the United Nations, which is basically a group of European states, established again that these rules of the game, but these rules of the game now are international rules of the game. And then on that premise, Britain established mandate over modern day Palestine. So British physical and economic control later facilitated Israeli settler colonialism that we see unfolding in front of us today. So in this case, the legal form was used to justify and facilitate alien domination, subjugation, and exploitation. So to get back to the to give you the overall idea, in this case, colonization first happened through economic coercion, changing the laws, and then physical coercion, and then it allowed for settlement. And settlement here is when people physically move into the colonized area and displace the local population in order to allow for efficient domination. And in this case, a claim to the land and its resources as a whole. And little by little, of course, what we have today is that a modern day case of colonization. And in this case, Palestine is very rare in the sense that it allows us to see the dynamics of colonization as they would have been hundreds of years ago, but it's a modern day case of exactly the same thing: alien domination, subjugation, and exploitation that is premised on the idea that one race is higher than the other and is allowed to dominate the other race and exploit the other race, and the other race is seen as subhuman. What is often missed out of the image is how corporations facilitate that. At the moment, one of the main reasons that the genocide in Gaza is still happening is because it allows for the accumulation of much more wealth in the world. Because corporations such as arms corporations that claim to be neutral, energy corporations, that are looking to invest the resources in Palestine alongside logistic corporations and others are making a lot of money out of this, and also then allowing politicians and giving incentives to politicians who will keep this happening and keep this exploitative logic of colonization that always comes hand in hand with genocide going. So to wrap up, I think, Tom, I'm running out of time. Or do I have a few more minutes? Is that one more minute?
You do? Yes. Sorry, I just muted myself, but you do.
Thank you. So, and I apologize that these are a lot of ideas and thoughts. This is just the premises of multiple ideas and thoughts. So I apologize if I've taken you on a very long trip. But historically speaking, what you learn in law school is that when one person causes harm to another, they have to compensate them for the harm done. In common law, this falls under tort law. In international law, this is called reparations. And the questions that I'll leave you with is, were reparations for colonization ever paid? When we think about colonization nowadays, a lot of the economic aspect of it and economic exploitation of it is hidden. And it's hidden because of the legal structure that allows us to think that the private is apolitical and the private gets to do whatever they want. The public-private distinction. And it allows us to normalize different forms of coercion and to normalize the domination of people, which at many points can escalate to mass ethnic cleansing and to mass exploitation over generations. So the short takeaways from what I've been saying is, law can be used to justify unjust behavior. And one of the most important themes that we start to unpack in critical introduction to law is the study of law and politics, and how the legal form can at some point be used to distort our understanding of the world, but at some points can also help us improve justice. And the corporate form can be used to hide power. This is a topic that we discuss heavily in international economic law, public law too, and hopefully when you're around, one of the other modules would be corporate accountability. And last but not least, one of the most important tools in critical legal studies is reflecting on history, or what we call the turn to history. We need to understand how we came to the world that we are in now in order to be able to move forward. So reflecting on colonial histories is essential to understand the world that we live in now. Understanding how these relationships came about to be will allow us to know and to have a clearer understanding of the reality that we live in and the truth that we live in, and allow us to, as lawyers, to answer the biggest questions that we should answer. What is justice? What is ethics? What is the law? And what is the best way to govern the world in a way that respects everyone's rights across the world equally? Thank you. And I give the mic to Tom.
Thank you very much. That's a really fantastic presentation. I hope everyone you can see a little bit more about what we mean when we talk about a critical law school and about the kinds of questions we'll be asking you to consider. So I've got a presentation that is focusing on the United Kingdom that builds on this. And I'm looking to ask about the legal and political implications of colonialism. So very often it's kind of presented in the media that especially European colonialism is something that is done, it's gone, it's in the past. But I hope you can see how even actions that took place centuries ago have had an ongoing impact and influence on people's lives in the 21st century. So I'm now going to share this. All sharing? You see that?
Yes.
Lovely. Okay, so as part of the blurb for today, we're looking at kind of the history of not just the UK, but European colonialism. And in terms of general questions, these, I'm not expecting answers for these now by any means, but these are the kinds of questions that we'd be asking you on our public law module. Public law is a core module. That's called constitutional law at other universities. It is the study of the United Kingdom's constitution. So I just want you to have a think about how much you know about the UK's constitution, because I believe it still is the case. It's not really taught in schools. And for the vast majority of law students, when they come to study public law at a university in a law degree, that's going to be the first time they actually understand what the UK's constitution is, how it operates, the rights and the wrongs of it. And it's very useful to do this today because it's an election day, and therefore I also want to consider if you have been voting or have the right to vote today, or you're old enough to vote today. Hopefully you're not unlucky like me and had like a summer birthday, which meant that you're too young to vote when the election came around the first time. How much you know about the UK's constitution. If the opinion polls are right, Keir Starmer is going to be the next Prime Minister tomorrow. How much power he would have, what the checks and balances of that power are, and also how much you know about the British Empire. So have a think about these. And again, if you have questions in relation to either of these presentations, please put them in the chat and we'll have some time at the end to deal with them. So, forgive me for starting with a quote. I have condensed this as long as possible. Professor Vernon Bogdanor was an academic at Oxford. He's retired now. He taught David Cameron, the ex-Prime Minister and current Foreign Secretary, at least for 24 hours. He's actually taught, I think, 4 or 5 Prime Ministers. He's taught them the Constitution. And this is him writing at the time of Brexit about the UK's Constitution. And so Professor Bogdanor is stating that countries normally adopt codified constitutions. Okay, now a codified constitution is when you include a constitution in one document. Like the United States is the classic example used in the UK media because it's an English-speaking country. It's probably the most powerful English-speaking country. But nearly all countries around the world have codified constitutions. It's a single document that includes all the rules of how to run the country. The UK doesn't. It's one of 3 out of 192 countries in the world that do not have codified constitution. Professor Bogdanor states that a codified constitution is adopted either through public debate or after what he calls a break in constitutional continuity. So if a country becomes independent, it draws a new constitution. It separates itself from its colonial past, or tries to. If there is a defeat in war or a revolution, the country normally creates a new constitution. But one of the reasons why Britain lacks a codified constitution is that we have never had such a constitutional moment. So the UK's unwritten constitution is broadly similar to the one that has existed for centuries. But that also means that the current 21st century constitution is pretty much the same as the constitution that existed through the British Empire. So the constitution that ran the British Empire, the constitution that helped Britain colonize a lot of the world, and I do have a map, there you go, that is the extent of the British Empire across the world. The constitution that allowed Britain to be so successful in those terms is still the constitution we have today. And I want to talk about an implication of this in a domestic level relating to the United Kingdom, but an implication of both Britain's involvement in colonization and also Britain's involvement in the slave trade. And as Shahad mentioned, the East India Company was also a company that was involved in the trade in human beings. So this is kind of a very dark area of our history, but it's one that has significance and implications for today. I'll explain to you. What I want to focus on, hopefully you can see my mouse pointer. If you can't, I'm going to focus on the British Indian Ocean Territory, which is this little bit in the middle of the Indian Ocean. The bits that are underlined in red are the bits that are still British territories, right? So there are still, strictly speaking, there is still a British Empire. It's a lot smaller than it was, but it is still in existence, and Britain still controls territory all around the world. Okay, So I'm going to consider the British Indian Ocean Territory, and I'm going to consider the role of the Chagos Islanders, also known as the Chagosians. Now, these are a population that is living in the British Indian Ocean Territory. They are British citizens as a result of colonisation. They have the same citizenship as a British citizen born in the UK, at least allegedly. But their particular history has found that it's afforded them many fewer rights than maybe people in the UK would enjoy. What I also want to outline, and we can get into this when, if you come and join us, we can discuss the prerogative in detail and in length. But the royal prerogative is a governmental power that still exists, and it was used to administer the British Empire. The prerogative was originally the personal powers of the monarch back in the medieval times. So they were the powers that the king or queen would exercise on their own, because they were, as the theory went back then, they were anointed by God. They were chosen by God to rule the country. They had these God-given powers. And today, a large amount of prerogative powers are still in existence. They are still in use, and they are used by government ministers. So when votes haven't stopped yet, but assuming the opinion polls are correct, Keir Starmer becomes Prime Minister, and then he has a huge amount of prerogative power. Now, in practice, what this means is that government can use a prerogative power without seeking parliamentary approval. So the MPs that you may be trying to vote for today, which comprise the parliament, are not actually, you don't need their consent or their agreement to exercise a prerogative power. So we have a large amount of power that was used throughout the empire, still today, lacking democratic oversight, and this was used in the case of the Chagosians to their detriment. This is a closer map. The land in the bottom left is Madagascar. The Chagos archipelago, the Chagos Islands, is in the middle of the Indian Ocean. A few hundred, about 800 miles away from Seychelles, 1,000 miles away from Mauritius. Why was it British? Well, it's British because of a European war. The reason that the United Kingdom gained control of the Chagos Islands was that Napoleon was defeated in 1814. And this was a year before the Battle of Waterloo, but as a result of a treaty signed in 1814, French colonies, the colony of Mauritius, which included the Chagos Islands, was transferred to the United Kingdom. So Mauritius was French, became British. Living in the Chagos and in Mauritius at the time were a large number of enslaved people brought there by France. So there was an enslaved population on the islands. Those French slaves, as the result of the Treaty of Paris, became British slaves. And they were mostly working on what are called copra plantations, effectively coconut plantations. So, Chagos Islanders are descended from enslaved people who were actually kidnapped, bought and sold to bring to the Chagos Islands. And they are British through no choice of their own, but because 200 years ago, over 200 years ago now, a British army defeated a French army, and that led to a peace treaty. Now, after World War II, Britain was running out of money. And so the decision was made to give up much of the empire, formally, but to retain what known as key strategic points. So the British wanted to retain the Chagos Islands because it is midpoint between India, Africa, and the Middle East, and therefore it makes a really good place for a military base. The Americans wanted to put a military base on Diego Garcia. The problem was Diego Garcia was claimed by both Mauritius and the Seychelles. So the United Kingdom gave Mauritius and the Seychelles a choice. Either you become independent and give up your right to the Chagos Islands, or you don't become independent at all. And as a result, Mauritius and the Seychelles made a decision. They felt they didn't have a choice. They had to give up their claim to Diego Garcia and the Chagos Islands in order to become independent. So the BIOT, the British Indian Ocean Territory, became British. To give it some legitimacy, we created an emblem and a flag. Here they are. These are the emblem and flag of the British Indian Ocean Territory. And this is the picture from an aeroplane of Diego Garcia. There's an American airbase. You see there's quite a large cloud going from left to right. Directly underneath this is an American airbase. This is a very important American airbase. The American Air Force used this to fight the wars in Afghanistan and Iraq. It's very strategic. It can really basically reach the airplanes can reach any point of the Indian Ocean basin as a result of launching from Diego Garcia. But there was a problem. So the base was set up, but there was a problem. The problem was the Chagos Islands. The US government wanted all the islands uninhabited. They wanted the Chagosians gone. And so the British used the prerogative. In other words, they used a power that does not need parliamentary approval. You don't need to tell Parliament what you're doing. We used the prerogative to buy up all of the coconut plantations. We also officially denied the Chagosians' existence. They were not a population that had been there for over 200 years. They were called contract workers, and they were gradually moved off the island over the course of years. The last Chagosian was expelled from Diego Garcia in October 1971. So effectively, over the course of a decade, British citizens were not called British citizens. They were called foreign contract workers, and they were slowly removed from their homeland. The Americans thanked us by giving us a discount on Polaris. That's the nuclear weapons program. So we got cheaper nuclear weapons as a thank you for removing British citizens from a British homeland. Here are the Chagosians pictured in 2011 in London. They have long campaigns, decades-long campaign to be able to legally return home. That's all they want. They don't. Some of them don't even care about compensation. They just want to go home. It's a place where they and their ancestors have lived for centuries. So this ended up in the English courts. And maybe to your surprise, the English courts did not think it was unlawful to use the prerogative to remove British people from British territory. In 2003, the High Court made clear that the ability to impose such hardships, the ability to remove British citizens from British territory, is simply the essence of sovereignty. There's a prerogative power. Parliament has no say in how it's operated. It's just the government. And if the government decides to remove you from your land, that's legal. Right? It cannot, the second point here, it cannot be limited or trumped by other norms. In other words, your human rights claims do not count. The ultimate power of the British state is to control its territory, even if it means removing you from your home. The UK government in 2004 made two pieces of legislation. These are two prerogative orders in council. These declared that the Chagosians could not return home. Now, you may know a little bit about legislation. You may have heard a bit about legislation. You may follow legislation. Normally, legislation involves debates in the House of Commons and House of Lords. It involves people voting on it. It involves press pressure and pressure groups. The prerogative involves none of that. Prerogative legislation, and I will, even though we're short of time, I will explain it to you in its entirety. Prerogative legislation involves this. A minister of the Crown, government minister, goes to Buckingham Palace. The king, as he is now, walks in. The government minister reads out the title of the legislation, i.e. the order in council to remove the Chagosians from their homeland. The king says approved, and that's all. That's law. We are using ways of governing territory and ways of lawmaking that we did hundreds of years ago to build an empire in 21st century Britain to remove British citizens from British territory. In that sense, the UK's constitution is still colonial, right? It's still based on the British Empire in many fundamental ways. So the prerogative can also be used to make laws that Parliament have no say on. No debate, no votes. The king just approves and the legislation passes. The major case in the Chagosians' kind of struggle was decided in a case called Banku. If you want to note down the name and look it up, there's huge amounts of resources online. This came before the House of Lords in 2008. And forgive the kind of legalistic language, I will interpret this for you. But the House of Lords basically said that the United Kingdom government is entitled to legislate for a colony in the interests of the United Kingdom. In other words, if the UK government wants to exploit a colony for the benefit of the United Kingdom, it can do so. Right? No doubt she is also required to take into account the interests of the colony, but there seems to me no doubt that in the event of a conflict of interest, she is entitled to prefer the interests of the United Kingdom. If it benefits the United Kingdom to remove British citizens from British territory, this can happen legally. And what we're going to do in public law is we're not just talking about what the Constitution is. This is an example of the kind of cases we're looking at to ask, does it work? Who is it working for? Who is it not working for? Or to put it another way, you can't understand the modern UK Constitution without understanding the past and present influence of the British Empire. This dovetails nicely with what Shahad has been talking about in terms of colonial companies and how they've shaped the world. A lot of the powers that Keir Starmer likely will be able to use are prerogative powers. So even if you voted for Labour, or even if you're going to vote for Labour and they win, a lot of the powers that the government are using are not controlled by Parliament. They are powers from an ancient medieval source. And ultimately, British sovereignty means the absolute right to remove you from your homeland. You have no right to live here. You have no right to stay where you're staying. The government wants you gone. They can remove you. And the courts are happy with that. So normally a constitution is there to give rights to the citizens, to ensure that citizens have rights they can uphold against government. We don't have that in the same way in the UK. And so another point we're going to be looking into when you come here across the first year in critical intro and others is asking ourselves, does this system work? If not, how should it be changed and why? And I will leave that there. Stop share. Stop share.
So
Sorry,
yeah, no, perhaps if just by their following up, there's the Chagos case went all the way to the International Court of Justice, and the International Court of Justice found against the UK, and the UK is still very reluctant to take that forward because it was an advisory opinion. But it's interesting to see, like, a good part of the discussion is always around the interaction of the international and the national, and how the national shaped the international. So perhaps if we open up the floor to any questions or inquiries you guys might have. We've been talking for a while. So please use the raise hand option. You're highly encouraged to do so. Any comments?
Or about the degree as well. I mean, we're happy to answer.
Also, if you're a bit shy, you can do it through the chat option. And perhaps we could guide you also. Like if any of you are willing to tell us if anything of what we've said shocks you, Guevara.
Hi, yes, I just wanted to chime in to say that was a really excellent presentation. And I don't know if there are any students here from, or possible students from the Caribbean, for example, because that's another area of where, colonized by Britain and falls very much within the scope of everything that you've been talking about. The point that I want to make, and again, if there are any students who are coming to Kent from the Caribbean, they would know about this. So on the point of the Constitution and how one is given a prescribed and a written constitution when colonization ends, it's that in the Caribbean, for example, it's imposed. So Britain passes an act of parliament to grant a constitution to these islands. And it is these, well, I'm from the Caribbean, let me just say that as well. So it is this constitution. So for example, I am from St. Vincent and the Grenadines, and our constitution is called the St. Vincent and the Grenadines Constitution Act of 1979, passed by the British Parliament. So it's something that's imposed upon us, and it's very, very difficult to change. So there are some entrenched clauses, for example, where you need 1/3 of the vote of parliament to get it done, and that is sometimes very often difficult to achieve. And when it goes to a referendum, you need 2/3 of the people in the country voting for this change, and that also is very often very difficult to achieve. So the imposition of these written constitutions after colonialism is just another exertion of power. And so that even though these Caribbean islands, who are former colonies of the British Empire, might have independence on paper, they very much still are colonial entities because they are tied in by an act of parliament, which only the British Parliament can repeal and allow these people, for example, to have, or allow us, I should say, to really have sovereignty over our land. I just wanted to make that point to complement what you're saying, but really, really lovely.
Thank you. Yes, it is. It's just mirroring Shahad, what you said. I mean, you can't, if you don't discuss the history of empire and colonialism, it is impossible to understand the state of the world. So it is, there is a certain rhetoric, especially in this country, that this is something that's past and gone, that this is something that we've kind of given up. But yeah, Guevara, you're absolutely right. The decisions that have been made by the United Kingdom, not just in recent decades, but centuries ago, are having a real and significant impact on the lives of people alive today and their children and their children's children. So these are the kinds of questions that we're trying to ask you when you come to Kent. These are not easy questions, right? They're not questions that has an easy answer, but it's trying to get you to think in a way beyond the rules, beyond simply the text of the document. And that will enable you, even if you want to become a lawyer or you want to do something else, it will enable you to improve or gain a way of thinking that will be of benefit to you in the longer run, so you can approach issues or challenges in your future with that kind of criticality. So this is what we mean by critical, basically. And Shahad, hopefully you're in agreement with this. We use it a lot, but this is what we mean. We don't simply mean tell us what's bad. We're thinking about a way of thinking and a way of being with these kind of materials.
No, so the biggest contributions that you'd see coming from colleagues at the law school would be more or less critical contributions to changing laws in a ways that are much more just and equitable. And there's one question and now two questions. So the first one is, how did you get involved in international law? So it started in law school for me. I was a part of moot courts, which you will find many opportunities to engage with at the law school. I always knew that my area is affected by war. It's a personal story, and I always wanted to kind of be able to represent my people abroad, which kind of led me towards learning the language of international law. And then asking the question of whether or not you can use the master's tools to undo the master's house, or do you need to create new tools? Usually what I tell the students is perhaps we need to make our own tools, and that's what we need, and that's what we can use critical thoughts thinking for, in the sense that for example, my work includes a lot of practice. I engage a lot with UN institutions, with international organizations and NGOs, but then with the critical output, I always focus on giving as much possible, and the word here is agency and power, to the affected people, but then also in the minds of the students, to undo how sometimes the law can be very limiting to our ways of thinking and our understanding of justice generally. Like as Tom and Guevara noted, like the repetitive transplant of laws denied us a lot of possibilities and how better ways we can engage our world. There is a second question in relation to whether or not this topic would be further discussed during the course. Of course, indeed, at multiple fronts. So colonization. So a part of our curriculum is very focused on decolonizing the curriculum. So particularly at Kent, we're very focused on going beyond what is usually called Eurocentrism. So we engage with authors, thinkers who go beyond these kind of limited mainstream ways of thought quite across the board. So you will hear people in land law discuss colonization with you in different aspects of private law, but it will feature quite said in a critical introduction to law and in the international legal modules. Generally, you will be engaging with third world approaches to international law. We have a whole module on post-colonial theory as well, if you're more interested in the theoretical aspect of that. At Kent, very luckily, we have a very wide range of international law modules that go across the economic and the public side, and it's very rare to find a law school in the UK that teaches international economic law the way we do, in the sense that we are engaging with live cases on the ground, because we're pioneers in socio-legal approaches. So for example, international economic law, I'll tell you about the history of colonization, but then I'll tell you how these dynamics play out in cases. So we'll be looking at case studies through documentaries, through cases happening on the ground. And here we look at another important keyword, which is how neocolonialism works. And this is both discursive, but at the same time engaging. So we get to learn the law, but then we get to learn how to be creative with the law. And now we're looking towards partnerships with a lot of international organizations that engage with such work. So yeah, hopefully that answered your question. Maybe also, Tom, if you want to take it in relation to discussing this topic further in the course.
I think that was a very thorough answer. I think all I'd add is, yes, you'll have an opportunity. There will be compulsory modules where this is discussed, like you mentioned, with land law, and there are also optional modules. So you will have the opportunity in the optional modules to go into more detail. We do have still a wide range of options available, and we do have really excellent staff across the board who really will be interested in your views and ideas and trying to think about this more deeply with you. So if you come along, give us your views, they're always going to be welcome. Some of the best discussions I've had have been with really engaging debates with a lot of different viewpoints shown.
And a lot of students also follow up if they have a personal interest in a specific case in dissertation modules. So that's when, after you've kind of accumulated all the tools you need, you start your own journey with a specific topic or community that you are interested in looking at the issues relating to. And also, one very nice thing is that we come from very broad geographical spectrum. So we have people who have engaged with all the, a lot of the different jurisdictions are covered, and which would allow you to kind of have an eye into how the discussions are also happening locally from the scholars that have engaged with the discourse in these different jurisdictions. Any other question or perhaps anything shocking that you found here, or if you've heard about such themes of colonization, empire, and ingraining them into the law, through constitutional law? So we have another question in relation to course structure. How often are moot trials conducted? So that depends on the module. So each module, you have a lecture and a seminar. So the seminar is often the more engaged part. The lecture is more where we give you the content. And the seminars can be designed differently according to the topic. You'll find that more in optional courses, I think, in the sense of mock courts and moot courts. style where you would be given that exercise prior. So for example, in my public law 2 module, we have a special study in relation to corporate accountability, and there we look at arms corporations and private military contractors. And what we do is a moot or a mock trial where different students take on different roles as if we were in something called the OECD National Contact Point. So we hear different perspectives on corporations that are supplying arms, and how is it that we navigate the law around them. So that's within the class structure. But outside the class structure, we partake usually in national moot court competitions, and we have people who are designated for that purpose. So there we will be announcing the different moot courting options that come about, and then you can engage with that, engage with those. Usually students would apply, and they would be chosen for the teams to go on the national competitions. Tom, if you have
That's pretty much it. Absolutely. You have modules that do it, you have extracurricular that do it. There are a lot of competitions that are run every year at different parts of the year, and also for different years, I think. So you have ones that are open for finalists, ones that are open maybe for first year students. So yeah, hopefully you'll come and study with us. If you do, you will be contacted regularly with these opportunities via email. So just, I would say sign up early because they are popular.
And also there is the law clinic. The law clinic will allow you to practice law. So in that sense, the law clinic is an optional module, and it is run by colleagues who are also practitioners. So there, what will happen is, as a group, you will have a case and you'll work on the case together. So that's not mooting, that's actually serious practice that you can partake in through the clinical option.
Absolutely.
Anything else? And reflections on empire, colonization? I think we've already run out of time.
Yeah. But thank you for the questions. It's always good to hear. I mean, if you have any more, yeah, you can get in contact with us. More than happy to answer.
Or any feedback, anything that has shocked you, anything that will particularly stay with you today? Anything that, if anyone asks you what you've learned today, one sentence to remember. Hopefully there is one sentence to remember. Okay, I have a shy crowd.
That's fine.
Okay, so I guess we close it at that.
I think, thank you so much, Shahad. Thank you so much, everyone, for being here as well. Yeah, I hope it's been interesting. And for those of you who, you know, if you're willing to stay up tonight to watch the results come in, you can join me in doing so, because that's what I'll be doing. But I wish you all a very pleasant rest of the day, and hopefully I will see you all in person at some point soon.
Yes, and again, just just a very warm welcome from all of us, and we do hope to see you in. And a reminder that, yeah, generally KLS is a very international space for all of you joining us from all the different places, as you can see from the type of teaching we give. So hopefully see you guys on campus if you decide to join us. Thank you for your time, and we hope that you learned something useful today.
Thank you.
Have a good day.